So our attendees are all jumping in right now as we turn this on. We'll allow a few moments for everyone to appear and we'll dive right into it. And I will repeat this message once or twice until we're all sort of fully ready to go. It's a well-attended webinar today, and we want to make sure everyone gets a chance to capture it from the get-go. Naturally, anyone can watch the recording following as well. So I will start just for the effect of time. I know we have a full agenda and lots to do. So welcome everyone to our fourth Bill 96 webinar in the series. It's been an exciting series with lots of topics to cover and a lot of light to shed as the legislation has taken its shape and is being understood better in the marketplace. And today is just the next foray with a bit more clarity that is now become available, still more needed. So I wanted to start with a very brief introduction of our speakers. And I will start with strictly alphabetical order, André de Maurivez, who is senior counsel at CIBC and second time attending or rather speaking at this webinar. So it was the first one that was kicked off last spring, and now here joining us here for almost a year down the road. And Keyvan Nassiry, who is also joining us here for the second time, the first time being that initial webinar in spring as well. Keyvan is the principal at Nassiry Law, and he's also a lending and debt finance lawyer. Amongst other things, also both of them great guys. So what better way to have a panel with two gentlemen that have been highly involved in this process. So André and Keyvan, if I could ask you to just tell a few more words about your background before we dive into the content, that'll be a great start.
Okay, Keyvan, do you want to go ahead, or
actually, why don't you go ahead, André?
Okay, thanks. As Gary mentioned, I'm senior counsel here in Montreal for CIBC, and one of my responsibilities is the Charter of French Language for CIBC and all its affiliates doing business in Quebec. I also take care of commercial banking, business banking, and wealth and capital markets. So those are my specialties on a day-to-day basis at CIBC.
Hi, everybody. Keyvan Nassiry. I know there are a few of you on the line who already know me, but thank you for joining. We're really excited. This is such an important topic, and hopefully in the next hour, we'll make some sense out of it for everyone. I started my firm, somebody told me about the pandemic 8 months before, so it's going to be 4 years this summer. After 25 years in big law, I decided to start my own shop predominantly in lending, financing of large institutions or smaller institutions on the lending side or the borrowing side. And of course, the Charter of the French Language. Let's deep dive right away. And I'll tell you about my background in a moment. But I want to start with 3 takeaways that we're going to have. There's going to be a few, but I want you to note that there is no bad questions, just like in school or in a boardroom. If you have a question, probably a number of people online have this question, so please use the chat. We're trying to keep this as fluid as possible. It's going to be a conversation at one point towards the end between André and I. Hopefully we will interact through the chat to answer your questions, and we may have to skip back and forth in some of the topics we're supposed to discuss today. So this background behind me, for those who attended what was April of last year, I mentioned that in the National Assembly of Quebec, le Parlement du Québec in Quebec City, for the last 110 or 20 years or so, this massive painting is right above the head of the MPs, and it depicts an event that occurred 230 years ago, literally, that's a while ago, where the National Assembly was debating in Quebec, the National Assembly of Lower Canada, as it then was whether we should use French, English, or both in debating in Parliament. It's fascinating for me that today we're looking at a topic that has been basically discussed for more than 10 generations. And now it's going to be a bit more jarring. If you want, by the way, real quick, this weekend, my wife and I were watching the movie Elvis. It's an Oscar nominee. I recommend it. It's pretty entertaining. Why do I bring this up? Because for those, I'm sure there are a lot of people on this call who were even not born when Elvis died, but what the chart of the French language, where we're going to talk today, and section 55, not to make it specific to that article, it was adopted, and it's been the law of the land in Quebec a week or two after Elvis died, for those who are history buffs. So it's been a while since contracts have, the law of contracts didn't need to fuss too much with the French language laws of Quebec, because as all the lawyers, whether in Quebec or outside of Quebec, who deal with Quebec parties or Quebec assets, or there's a nexus with Quebec, you already know, we used to, and we continue, and certain times we will be able to do this. The trick was just put a language clause. Let's put in a clause that says that the parties hereto express their choice to contract in English only, and then we have the same blurb in French, and you're done. Now, there's some changes happening, big changes. So I want to first start with those three takeaways. So not to create panic, there is some good safe harbors, I like to call them. And as a good lawyer, let me give you some disclaimers. None of the things André and I are going to be talking about today have been really tested by the courts post Bill 96. Bill 96 is what has really amended, overhauled the chart of the French language. So it's a brave new world, but there is some confidence amongst the Quebec lawyers who have reviewed this, have thought about this. And hopefully as we progress towards June 1st, why June 1st? Because that is when all of the things we're going to talk about are going to become important for everyone who's listening. So we have a few months to go. We have a few months to get our head around it, analyze it more, debate it more, and hopefully come to a consensus. The bill is something that's changing in for the first time, something that has been appearing anyway to the market as very jarring. It's something I've noted over the last few months talking to clients, whether in Quebec or outside of Quebec, that's never mind the politics of it or why we have to do this. They're getting fearful that Quebec is going to become either too expensive or too complicated or unsafe legally to do business. I personally disagree, and hopefully some of the ideas we're going to share today are going to be reassuring, because the three takeaways to talk about those is, if you're really dealing with a commercial contract, not a consumer contract, but commercial contract that is definitely negotiable, don't worry about it. You're good. You don't have to worry about any of this. But it has to be legitimately negotiable, not negotiated. The other principle is, if your commercial contract, not a consumer contract, is a non-negotiable, you want to impose it on the party, but you, for instance, the imposing party, for instance, you're outside of Quebec, so you are some form of company who has a head office outside of Quebec, or your decision-making is outside of Quebec, you probably will benefit from an exception, so you don't need to worry about any of this. And finally, there is another way of carving yourself out of this. All of this has to be factually legitimate. You can, for instance, say, well, I'd like my commercial contract to be governed by Ontario law or British Columbia law or the laws of Illinois. That would probably, most probably, according to the latest analysis, put you outside of the ambit of the things André and I are going to talk about, so long as there is a legitimacy in having that contract governed by a non-Quebec law. So if you're going to choose Ontario law, make sure there is an Ontario element in it, because that's something that the courts would look at to see if that's legitimate for you to avoid the applications of the charter. For the lawyers in the room, take a piece of paper. I'm going to repeat this once. We can ask in the chat, or maybe share it in the chat, or later you can ask us. But if you want to do your own analysis, certainly if you want to have some good material to fall asleep, I mean this is mind-boggling, but it's really yoga for the mind. It really is. But take the following sections of the laws that I'm going to mention down for your own analysis. Get back to us if you have any questions. So in the Charter of the French Language, section 55, section 21, section 21.5, 20.4, 204.15. So 55.21, 21.5, 204.15 and following. Those are the articles that we are going to be summarizing for you. We're not going to put it on the screen, but if you want to look at it, please do. Consumer Protection Act of Quebec, section 26 and 6.3 of the CPA regulations, the regulations adopted, regulation 3. And finally, the Civil Code of Quebec, 3111, 1379, and if you really want to have some fun, 3079, 3079 of the Civil Code. Those are the main articles of law that would require analysis in order to come to the conclusions that André and I are going to share. So what is the new rule if you can't benefit, for instance, from some of those 3 principles that everybody's fussing about? Well, the law has been on the books since June 1st of last year, and they gave 12 months for the following new rule to come into force. June 1st of 2023, any contract that's predetermined by one party, let's call it an adhesion contract. If one party is imposing terms on another party, then that contract and the related documents to that contract must be systematically given to the Quebec party in French. So if you're used to having your documents in English, whether it's 2 pages or 200 pages, and you don't have a French version of it, you're going to have to worry or be preoccupied or start planning, if you haven't, to have a French version of those contracts. And I don't, right away, I'm going to put this out there. Translation is not a bad thing. I've always said, even well before Bill 96, when coming to Quebec, you should have French documents. Of course, in financial markets, it's a different argument, but if you are catering to a Quebec clientele where the predominant language of your counterparty is French, why not have French documents? So going back to the principle, it starts off with any contract that's the terms are imposed, a predetermined contract or adhesion contract, that's a better word for it. That contract has to be in French. There are some exceptions, I'll get to that in a moment, but what you want to know is that this is basically a subjective test for, you're not going to have this stamped on the agreement, this is an adhesion contract or predetermined. This will have to be first argued before a court of law, and the person who needs to prove or may fuss about it that it was an adhesion contract is the so-called adhering party, the weaker party. It's up to them to first prove that the contract was one of adhesion. And the best way for the contract factually and legitimately not to be a contract of adhesion is if you can legitimately prove to the court, so plan your transactions accordingly, that the contract was negotiable. Doesn't mean it had to be negotiated, but so long as there is an opportunity for free debate, free discussion about the terms and conditions. I want to stress that this has nothing to do with consumer contracts. Those have the same rule, and there are very few exceptions for consumer contracts. But when you're dealing with a commercial contract, it's important to know that if you're dealing with a party that's based in Quebec and your contract is either governed by Quebec law, or for instance, you want to make it governed by Ontario law, but there is no legitimate reason for it to be governed by Ontario law, you may not have no choice but to think about the Charter of the French Language, section 55, and all those articles I just mentioned, and say, well, do I need to worry about this contract being in French and getting it translated or remitting it? And the remittance is something that we'll talk about hopefully towards the end. It's very important. You have to be able to prove that the French version of your contract was given, step one, to the party in Quebec. And it's only after that party says, well, no, I prefer to sign in English, please. Then and only then can you then remit your contract in English. So for those who have an online platform, your IT needs to know about this. I'm sure hopefully they do. You need to make sure that there is this step process. And for the transactional lawyers, hopefully we'll get to deep dive on this. I think someone should be on mute. Anyway, I'll continue. We can, through certification by an officer of the contracting party, we're talking about the corporate level, to get the parties to confirm, yes, we received the French version. It was our decision to not sign in French. We want to sign in English. Alternatively, you can also have a certification for the lawyers there to get yourself comfortable that the parties had an opportunity to negotiate, right? Because if a contract is negotiable, not necessarily negotiated, there was an opportunity for debate, then you don't have to worry about the rules. Let me take a few moments and talk about the exceptions. Those are important. They're very, I would say, poorly drafted, unfortunately, in the law, but they are there. They're meant to have a meaning. We need to give them a common sense meaning. One of the exceptions right out there is a loan agreement. Not every contract of financing is a loan agreement, unfortunately. Lines of credits, there's a debate whether a line of credit is a loan agreement. I won't get into the reasons, but it probably is. But an installment sale, a commercial equipment lease, a factoring agreement, a contract of securitization, a master purchase and sale agreement, a note purchase agreement, there may be financing documents or contracts, but they are not loan agreements, full stop. So you can't benefit from that exception. Loan agreements, however, if your contract is one of I'm lending $10 from Mary to Joe, that's a loan agreement. You don't need to worry about the new rules. So you don't have to translate your document to French. Another exception is the employment contracts. We don't worry, we're not going to brief you guys on that. I believe there was a webinar on this with Alexa. It was actually, hopefully there'll be a follow-up because that's going to be occupying a lot of time and analysis. Derivative contracts, future contracts, interest drops, those kinds of things, contracts with clearinghouses, they are also benefiting from that exception. We won't go to that. But the two main takeaways, additional takeaways, loan agreements, don't worry about this. The more important takeaway is if the contract is being signed with a person outside of Quebec, then you have very good odds that your contract is in the exception and you don't need to worry about this. We'll talk about how to interpret that exception in a moment. Let me take a moment to tell you about what we did. André and I are part of a committee real quick. Over the last 12 months, we've had an active role in getting all the major firms in Quebec, law firms, to think, and these are lawyers who predominantly practice in financing, like André and myself, to think about the implications of Section 55 of the Charter, which is that new rule, that three-step rule. And we analyzed what the Minister of Justice of Quebec mentioned publicly in his declarations about a year ago today, almost to the day, in fact, early February, where he said that the new rules are not meant to apply to businesses. B2B, a business-to-business contract, not a consumer contract, that contract needs to need not worry about the new changes because they don't want to hinder business and they don't want to hinder Quebec businesses doing transactions with the world outside of Quebec. Unfortunately, we do not see an explicit exception for B2B contracts in the new law effective June 1st. So André and I and about 90 other lawyers, we signed this long 3-page letter, but very eloquent, we'd like to think, where we asked our new Minister of the French language, we have a ministry called the Minister of the French language, it's a new creation since the adoption of Bill 96 last year, for him to please consider clarifying the language of the law to reflect the intent of the lawmaker as it was publicly disclosed during the parliamentary debate. We signed that letter about a month ago. We're still waiting for a response. We're actively following up. So which means that maybe between now and June 1st, we may get an exception. So if hopefully that happens, then some of the preoccupations that the people on this call or this webinar may have may not be may not end up being accurate post June 1st. But of course, don't bank on it. That hasn't happened yet. If and when it does happen, it will be publicly known for sure. So why don't I stop on this, and I'll pass it on to André, and he's going to talk about the breaches. What happens if we don't follow the new rule of preparing the document in French, and then remitting the English version.
And Keyvan, just before André goes, as a housekeeping item, I know there may be a lot of people in the audience that are encountering this for the first time, or rather early in the process. So if you have any questions, please feel free to throw them in the chat. And we're going to do one of two things. To the extent that we can address them throughout the presentation, I'll introduce them to our speakers as we go. And if any of them we don't get to during this, so we'll send a summary following the webinar, and we'll try to address some of those questions after the fact, knowing that there's only so much you can do in an hour, but there will certainly be follow-ups to this webinar as well. So André, on that note, Section 55 breaches.
Yeah, before I get into the consequences of breaching Section 55, I was just going to mention two other articles that one is completely new that Bill 96 brought in, which is 50.2. And then there was a significant modification to an existing article in the Charter of French Language, which is Section 52. So in both cases, though, basically the government wanted to ensure that the Charter of French Language truly applies not just to consumer contracts, but also to contracts with B2B on a B2B basis, aside from the exemptions that Keyvan just mentioned. But really what they're after with those changes is also ensuring that basically going forward, any enterprise wanting to do business in Quebec needs to ensure that there's a French equivalent of the services being provided in Quebec, and that the documentation that's available in Quebec is also available in French. Obviously, as Keyvan mentioned from the get-go, if you're doing business in Quebec, you would think that's pretty well common sense and that you would already had pretty much everything available in both languages. But I think the fact that Bill 96 is coming to play, it's a good idea to review your current documentation, your current products and services that are being sold or marketed in Quebec to ensure that you actually do have a French equivalent of those services and documents. So the section that I'm going to talk about now is really section 204.21 for those who like to read legalese. That section basically states that if a party is found to be contravening Section 55, which is what Keyvan just kind of outlined, that adhering party to a standard contract or contract of adhesion, as Keyvan mentioned, basically can invoke the nullity of the contract. So the consequence really, if you don't provide a French version of a contract of adhesion, is the client, whether it be a business or individual, could file a complaint with the language regulator, which is the OQLF, l'Office Québécoise de la Langue Française. And basically, they don't have to prove that they suffered any damages. In fact, what happens is the party that basically provided the contract of adhesion has to show that the adhering party suffered no injury. So it's a bit of a shift in the burden of proof. In this case, it's the defendant that basically has to demonstrate that the plaintiff didn't suffer any damages in order to ensure that the contract of adhesion isn't considered null and void as if it never existed. So it's a fairly serious consequence. I'm sure right now there's obviously no jurisprudence. This only comes into play on June 1st, 2023. Our understanding from the OQLF is that there will be a non-formal or informal transition period. They're not going to start cracking the whip as of June 1st. They're going to give enterprises some time to ensure that they're meeting these new requirements. But my guess is sometime by 2024, we're probably going to see some cases before the courts, and it'll be interesting to see how the decisions come out. What type of facts the judges are looking at, what they're taking into consideration, and so forth. So I think from a legal perspective, it'll be an interesting couple of years ahead of us with respect to the Charter of French Language. So having talked about the consequences of contravening Section 55, I thought as an in-house counsel, it might be interesting for some of you to give my perspective on some practical considerations that should be taken, that you should think about with your business partners. So, I mean, namely, the key thing that I think one needs to think about is, how do we do business today with contracts of adhesion? Do we have an English version and a French version? Do we want to now perhaps make a bilingual version? And it's been clearly agreed upon by the legal community that a bilingual contract of adhesion would meet these new requirements that came out in Bill 96. So obviously, that means potentially creating a new form which would be used just for Quebec. There's pros and cons with a bilingual contract. A pro is you basically you can ensure that you're meeting the new requirements because there's only one contract that needs to be provided to all clients in Quebec. I guess a con with that though is, a francophone could be offended by the fact that they're receiving a document that's 2 times the length because there's an English component to it. Another complicated part or thing to take in consideration if you're going with a bilingual contract is, are you going to put the French part first, followed by the English? Or are you going to put the English first, followed by the French? Or probably the best solution is to have 2 columns. One, to take a page, you cut it in half, you fold it in half, you have the French on one side and the English on the other side. And so, Article 1 matches the French and English, Article 2, and so forth. But these are all kind of things that, as in-house counsel, you need to start thinking about and having conversations with your business partners, because as Keyvan said, we have a little more than 5 months to meet the new deadline. And there's a lot of advantages and disadvantages, and you kind of have to decide which ones are, and it will vary depending on the type of business you're in as well. So I think another practical consideration that you need to take in account is, how are you selling your products and goods in Quebec? Are you doing it in person? Are you doing it online? Are you doing it by phone? I mean, those are the 3 main methods of providing your products to Quebec residents. But obviously, each of those means potentially means different ways of dealing with providing a French version of the contract of adhesion to all clients. Obviously, if you're dealing with a francophone client, it's pretty easy because you would have given them a French version of the contract to begin with. But if you're dealing with a non-francophone, that means now you have an additional step that you have to do. I mean, if you have a store, for example, or your business, and you're dealing with the client in person, and you're speaking in English, chances are the client's going to want an English version of the contract. But going forward, as of June 1st, 2023, you're going to have to provide a French version first, remit a French version. And obviously, remitting a French version is going to be different depending if you're doing it in person, if you're doing it online, or by phone. The other interesting part is, and this has been discussed quite a lot amongst the legal community, is, can you provide a blank version of the contract of adhesion? So in other words, are you required to complete the entire contract of adhesion with the client's name, the client's address, the date, or can you simply provide a contract of adhesion that has those elements that are blanked out, i.e., what we would consider material elements of the contract? I won't give you my legal advice on that, But it's something that you guys have to consider and discuss. I think the majority of the legal community thinks that a blank version is possible, as long as, again, you're not dealing with any material clauses that haven't been completed. So, I mean, the question is then, again, from a procedural perspective, are you going to have a blank version that you give to an Anglophone? So then you can say, okay, I've met the requirement of remitting a French version, and then the client's going to say, now, okay, give me an English one, please, so I can understand what I'm signing. And then you complete the English version, and that's what the client signs. That's quite easy, obviously, in person, but online, there is no one-to-one going on unless you're using the chat function. So how do you deal with that online? Do you provide a link to the French version on the English side of the website? I guess the first question to ask is your website fully bilingual? Technically now, under the Charter of French Language, you need to ensure that your website's fully bilingual. Most websites have on the top right-hand side, you can click between French, English, or any other language that your business might be using. So toggling back and forth. But then what does that mean? Like, from a technological standpoint, does that mean the English now part of the website needs to be changed, because you now need to somehow ensure that there's a French version of the contract that's remitted to the clients? One solution is potentially, again, if you have the email address for the client, you email a French version to the client as soon as they start the process. But again, depending on what type of business you are and the demographics of your clientele, not everyone today has an email address. So again, you have to take that in consideration. You try and use that, and then have a secondary method of dealing with it if you do have a client that doesn't have an email address. So yeah, some of the things that I've heard and I've seen is links, sending the French version by email. You know, how much proof do you want also to record proof that you've actually remitted the French version? That's going to be, I think, one of the key things that's going to come out in the court cases in the next few years, is how much proof do we need to have that we've remitted a French version to a non-Francophone? And the reason why I say that is because, again, the burden of proof is going to fall on us to demonstrate there was no damage to the client. But also, if the client basically states, you never provide me a French version, and they have a crafty lawyer who says, well, you know, maybe we'll argue that you didn't get a French version. How does the business demonstrate that they actually did provide a French version? And then by phone, which is the other main method of doing business. Again, it's similar to the online version, but slightly different, because sometimes on phone, and when you're doing business by phone, you actually start completing the contract over the phone. And so you have to determine, well, if I'm doing that, how do I ensure that I provide a French version? Again, can you text the French version to the client? Again, based on demographics, you might not have clients that have a mobile phone that has necessarily either have a mobile phone, or secondly, have a mobile phone that has data to it. So again, something else to ponder. So you have to start looking at the different ways of how do you deal with the phone. One of the key ways that I've seen that's going to be probably put in place is that usually the application portion of the takes place on the phone, but the actual T&Cs, the actual contract of adhesion, is sent by mail after the phone call. And so they'll be sending both a French and English version by mail, or perhaps, again, if it's a bilingual contract, there's no issue. They're just sending the bilingual version of the contract after the phone conversation. So I think this also brings up the aspect of the language clause. Technically today, if you're doing business in Quebec, you should have already a language clause, as Keyvan referred to a couple of minutes ago. And that was to ensure that if you were dealing with an Anglophone, that the Anglophone clearly said, I want to do this contract in English, and I also want all the related documents in English. one of the questions that have come up is, what does related documents refer to? Does it include other contracts that might be related to that contract? So an example is a credit agreement, for example. So if you enter into a credit agreement, usually, the bank or the financial institution is going to want to have collateral. And to get collateral, you're going to have to sign potentially an hypothèque, or some other, you might have a guarantor that signs a guarantee and so forth. And those are all considered to be, so the question, first of all, is, are all those other documents considered to be contracts of adhesion? Again, it goes to what Keyvan was saying, was, were they negotiable? And if they weren't negotiable, can you at least demonstrate that they were negotiable? Because you wouldn't want to basically state, oh yeah, well, our opinion is they're negotiable, and then the judge is looking at it, if it ends up going before a judge and saying, well, you're a powerful enterprise with 40,000 employees and you're dealing with an individual here. I don't think the individual really thought that they had any negotiating opportunity on this contract. So these are all kind of facts and concerns that we have to take in consideration. But back to the language clause, if you don't have one, highly recommend you include one now. And if you do have one, should be updated. So, there's been a lot of discussions amongst the legal community on June 1st, 2023. What do we do? We got to prove somehow that we've provided a French version of the contract. So a lot of enterprises are tweaking their language clause to refer to the fact that, the client is confirming they've received a French version. And there's some enterprises that are going as far as actually requiring the client to initial that clause, unless that clause is just before the signature line. Again, as part of their proof that they have provided a French version, and that there's no minimizing complications going forward in the future. So, those are some of the practical considerations that I wanted to bring up and highlight. I thought they were important for everyone to think about.
Thank you, and I like that suggestion. Have that clause right above the signature line. Have two birds with one stone. And Keyvan, we have the lawyers in private practice here as well. So if I could ask you very briefly, sort of some advice for them as they're advising their clients around some of these items and sort of those suggestions. And then I'll ask both of you for some suggestions on sort of best practices for our audience as they prepare for some of these. And I'll introduce some questions as well. Sorry, Keyvan.
No, of course, thank you. And it's important just for the lawyers and just a shout out to all the translators. Walk to your boss's office and ask for a raise. You're gonna get it, I think. Jokes aside, I think it's important that all lawyers, whether in-house or or outside of the firms, external counsel, take this bill seriously enough for many reasons. One of which is Quebec has never been more open for business. Despite what this bill may appear, nobody likes change. But we have the lowest unemployment of recorded history. We have a government, again, regardless of where you are in the political spectrum, it's a government that's led by a former entrepreneur. Many senior ministers are former business executives, or they're running many of their departments more and more like a business, hopefully. And if there are, on the recording, if ever a civil servant or a senior politician is one day listening to this, shout out to them, and please do run the province more like a business. Do not let this law, if I may preach for a second, prohibit business in Quebec, because it's not that cost prohibitive, and Quebec remains one of the safest places to do business. It really is. Awards are low. It's far more continental European approach of trust in business. I truly fundamentally believe this over the last 25 or 30 years of practice. It's been my experience. And the legal practitioners on this webinar and your colleagues, I think we have a duty to educate ourselves about the new law, I promise you, it's like intellectual yoga. It's phenomenally interesting. It will bring you back to on the school benches in law school to understand and figure out the ambiguities and also take positions. What André and I are doing, and I love it, is that over the last 12 months, really there's a nice vibe that has been created. Almost every major firm that you guys would know on this call are participating in our initiative. And we are more and more approaching towards a uniform analysis. And this is what we want, because we will be the expert witnesses before the courts. So André was mentioning about the Office de la Langue Française, which is the watchdog, starting making waves. But I think before that, a trustee in bankruptcy will get some form of claim, and a creditor or a litigator will say, hey, you should argue this, and you should not recognize the rights of this party in this insolvency because the contract was of adhesion and it wasn't remitted in French. So I think that will no doubt be pleaded before the courts, and the courts will rely on their precedents, but also on expert witnesses, how the stakeholders will hire lawyers and those lawyers will argue before the courts, and also the practitioners who publish articles. I'm actually hoping to share this recording with some university professors in law schools that I know, who hopefully will buy in to the common sense analysis. So André, for an example, was saying, well, the pre-printed contracts. A classic example is the bank security agreement, whether it's a GSA, a general security agreement, or a hypothec, or a corporate or business personal guarantee with the blanks. Should I send the French version with those blank spots, which is like name, address, amount? Should I really fill those in for it to be a legitimate French version remitted or given? English version of the law sometimes says remittance, other times says to give. I think the doctrine of, come on, are you kidding me? If someone were to argue, well, I didn't see my name in the French version, is that going to be a pretext to cop out and renege on the contractual promise? I really would be disappointed as a lawyer. And I think it's our role as legal serious practitioners to educate ourselves, educate our clients, our peers. The second thing I think it's important, we lawyers who sign legal opinions, particularly in transactions, we have to be mindful of the purpose of those legal opinions. So if you're signing a legal opinion on regarding a contract of adhesion, and what are some contracts of adhesion, real quick, like an insurance policy, a public utility agreement. So even a business that has cable or internet, never mind a consumer, a law firm that signs internet or cell phone coverage or contract with Rogers or Shaw or Bell, that may be a B2B contract, but typically those contracts are not negotiable. Or if you're an alarm system contract, those are also non-negotiable typically. So how do you position yourself if you are negotiating contracts that maybe are negotiable, maybe they're not? The importance is that when time comes to sign legal opinions, the people who rely on those opinions, the secondary market, the legal firms in the US or outside of North America who rely on the legal advice of Quebec counsel. If you're a lawyer outside of Quebec, pair yourself up with a Quebec lawyer who understands the new rules. If you're a Quebec lawyer who will be signing a legal opinion for your client, or if you're a legal counsel in-house who needs to have an external counsel sign a legal opinion, please make sure that you are being pragmatic in your approach. This is so essential. Form a legal opinion working group, or if you don't have one in your law firm, get yourself updated so that we don't have these off-the-shelf opinions that appear jarring to the market. I cannot stress this enough. The last thing we want is for a school of thought to be developed to suggest that, oh, the French version of a predetermined contract with blanks, that's not good enough. I think that would be a foolish outcome in all modesty. One last word is that the importance of not alarming our clients as lawyers, to participate in the risk with them. and protect ourselves as lawyers, again, to, in emails, without making it overly complicated, but set out the facts based on which you are taking a position in your advisory to the client, or whatever opinion you end up giving. So we understand that you have given an opportunity for the Quebec party to negotiate the contract and so on. I think those are some of the takeaways for the lawyers. And again, those who will want to discuss this further, I'd love to hear from you. Reach out, we'll have a call or exchange by email.
Thank you, Keyvan. And I will ask both of you momentarily around some tips as people prepare for these changes, sort of best practices that you've seen in either of your scenarios. Keyvan, for you in the private practice perspective, and André from an in-house counsel perspective. Just a couple quick questions I wanted to introduce from the audience. So one of the questions was that there will be a recording of this, and we'll also send out a summary. And any questions we don't get to today, we'll attempt to do offline as well. But one of the questions was, what are some examples of a contract of adhesion? So let's say a standard form bank loan and security documents, or would this extend to security documents drafted by a lender's external counsel as well?
Should I take this one?
Hey, go ahead, Kevin.
So a classic example is a franchise agreement. Everybody knows what a franchise agreement. Case law exists that some franchise agreements, if they are negotiated or negotiable, not all of them are. If you own a Tim Hortons down the street, doubt you probably get a lot of, you have any clout. You're not a consumer now. Don't forget, you're a business owner, a franchisee, signing a franchise agreement with Tim Hortons or Burger King or whatever it is. Probably that contract is considered a adhesion contract, and you have to be then look into whether you can couch yourself in the exceptions. But you should start by the following analysis. I think the case law clearly has, the current case law anyway, not the pre-Bill 96 case law on contracts of adhesion, has suggested that in interpreting 1379 of the Civil Code, that it's not just the essential stipulations of the contract that are non-negotiable, it's also the important conditions. So not just the price of the goods that are being sold in a sale agreement or what's being sold, but also the extended warranty or the types of features without which the counterparty would have not signed. If they're important enough and they were still non-negotiable, then you probably fall more towards the adhesion contract, and then full compliance with 55 of the Charter, unless you're in the exceptions. Another feature the courts have looked at is, there's a deeming provision that if the contract is heavily one-sided, then the court will start by the analysis, okay, this is probably an adhesion contract because it's heavily one-sided. There's no equilibrium. So that's another, again, these are all subjective tests. They have to be proven, argued. But you would start with anything pre-printed, anything that says, here's our printed form. And as lawyers, we've often seen it. We try to advocate legitimately for our clients, and the other side says, well, no, these are non-negotiable. I got instructions not to negotiate because fees will go up, or we need to close tomorrow. Well, I don't think that's going to fly anymore if you don't want to comply with 55 and prepare your documents in French first. So I think those are some of the contracts, but it's a vast topic. There are many articles on it, lots of case law. Again, I don't think we'll have enough time to deep dive to the end, but happy to have these calls or emails with anyone who wants to probe me.
I would concur with Kevin just said, Gary, and I would just add that typically between an enterprise and a consumer, you're dealing with a contract of adhesion. It's very rare that there's negotiations that take place. And again, it goes to the fact that Kevin was mentioning, where you have, a very sophisticated enterprise that has 40,000 employees, and you're dealing with one individual. Again, and I mentioned it earlier, you're going to have to prove that, it was negotiable and demonstrate. And I mean that the enterprise is going to have to demonstrate to the judge why they considered it to be negotiable with this one individual. And in many cases, just because of the fact pattern, it's going to be it's an uphill battle for an enterprise in that type of context. In a B2B situation, I think there's more middle ground between the two enterprises doing business with another. Obviously, again, though, if you're dealing with a small, medium dépanneur on the corner versus a large supplier, again, it's similar to the context of consumer and business, but it all comes down to facts. So, and I
Dépanneur
think
is a convenience store for the non-Quebecers.
correct. Thanks.
Thank you for the translation, Keyvan. I know there are a couple more questions. If we don't get to them, we'll, like I said, we'll attempt to address them offline. But one question that was interesting, especially for anyone selling consumer products, etc., would an agreement to purchase a product online be a contract of adhesion?
I would say yes, because in that fact pattern, you have a consumer, you have an enterprise, and I don't see how the consumer is going to be able to negotiate the contract because it's online and it's take it or leave it type of situation. So I would say very little chance of saying that was not a contract of adhesion.
Yeah, Amazon Prime, Netflix, Spotify, anything you're signing online, I don't think it's non-negotiable. First of all, consumer laws will override to begin with. Never mind whether it's a conflict of law. That's 3117 of the Civil Code for the lawyers. Consumer laws will always supersede the law of the contract because the consumer by default is considered the weaker party, whether it's an adhesion contract or not. So you need to comply with Section 26 of the Consumer Protection Act, which paraphrases 55 of the Charter, which means that you remit the French version to the consumer. It's a few months now. Every time I order something on Amazon, the emails now suddenly have been converted to French. And I believe the English is at the very bottom. Somebody gave that legal advice, and it was a good legal advice to Amazon, in my view. If it's not a consumer contract, you could still be an adhesion contract. And if I'm a company in Quebec, a business, and I want to sign up Netflix for the cafeteria in my business for my staff, it's not a consumer contract, clearly, because the buyer of Netflix or the subscriber is not a consumer, it's not an individual, it's a business. And yet it is definitely an adhesion contract, and 55 has to be looked at. And then you need to ask yourself, where am I in the exceptions? The Netflix contract is not a loan agreement. Certainly, therefore, it can benefit from that exception. It's not a derivative. It's not a clearinghouse. It's not an insurance. It's not an insurance policy that's not available in Quebec. That's a 21.5 of the Charter. So, is it a contract with a person located outside of Quebec? That's a good question. Or Microsoft? Is it Ireland? Is it elsewhere? Where are the servers? Those are questions of fact, and will come up only at the highest level of complexities when we have to give legal opinions and so on. But certainly if you're a seller outside of Quebec, you're selling at the retail level to individuals, you probably have no choice but to comply with having a French version. There's some exceptions for online distance contracts. We won't get to those for consumer levels, but you need to comply with. But if you're not dealing with individuals, then you probably have more breathing room to see if you can stay in English. So long as, though, you always put that French language clause, which says that the parties have agreed to sign in English. That's all you need, a couple of lines, no translation.
Thank you, Keyvan. There is one question that I will try to attempt myself, and it was around lead times around translation. What type of lead times are you seeing? And I feel like I'm well positioned, being the business we're in, to address this. And I hate to give a lawyer answer, but it depends. And really depends on the length of the document. So I would say if it's a lengthy agreement, you should plan a couple of weeks for it, just so that it's not rushed. And I know there's translators watching this. They will tell you, because it's not like they have nothing to do. They typically have to add it to their pipeline of things they're working on. So that's typically wise to plan for. If it's a shorter, 2-3 pages of terms and conditions, obviously can be done much sooner. But it's best to plan for the lengthy lead time, and then it's far better to get it sooner than later. And feel free, André and Keyvan, if you wanted to add something on that note. But what I want to ask, and perhaps start with André, is any tips, sort of in the last 5 minutes, for our audience as they prepare for these changes?
Actually, it's a good segue you just made, Gary, because I was going to add to your comment. I completely agree. I think that the lead time is important because I think you want to get a chance to review the document once it's come back. And sometimes when it's a new translator, they might not necessarily use or be aware that you have particular language that you like using, or certain expressions. So I think that's important for the lead time, so you have a chance to review to see if it meets potentially your business culture. Every enterprise has kind of their own set of language and way of drafting things. So, and that with time, obviously, if you're using the same translation outfit, they begin to understand how you like things worded and so forth, and what type of expressions, and if you have a particular database of terminology that you'd like to use. So I think that's important. I would also add another reason why you want to have some lead time is, as Gary mentioned, is you just don't know how busy the translators are. But I can tell you I use translators heavily, and I would say that the shorter notice you give, the higher price you'll pay as well. And so obviously, if you have certain budgetary constraints, you want to keep that in consideration as well. So those would be my 2 points from your practical tips on that comment, Gary.
I'll add on to that, Gary, real quick on translation. If you're planning to translate to comply with Bill 96 or the Charter of the French Language, is because you want to deal with Quebec clients and customers, make sure that the translation company or translators in-house or those who use are versed in Quebec legalese. And I say this because the legal French in Quebec and the legal French in Ontario are not necessarily the same. So you can have terminology that may appear jarring to a court of law in Quebec, and you want to have the safest documents, right? And why do people sign contracts? They want to make sure that if ever there is a problem, some court of law is going to say, yeah, that makes sense. A promise is a promise. Your lawsuit is accepted, and you can go enforce it. The last thing you want is to have a French contract that is weak in its terminology. And I've seen a few right now. I'm helping a number of clients with the French version of their documents, and they come equipped with something they've been using in the Ottawa region. And I love Ottawa and people in Ottawa, but the language of the Personal Property Security Act of Ontario, which has an official French version, it is not the same as the French version of the Civil Code. So if that contract is to be used in Quebec, my legal advice is, if you want a quality document, your French document already that you have needs to be improved. So I think it's important that we cannot stress, if you're going to do it right. Hire responsible, qualified people, stay on them, insist on the best price, but give them a chance, give them a nice heads up. Don't wait to the last minute. This initiative that André and I and many others have taken on to change, hopefully, or clarify, create an exception for B2B contracts that may not be successful. The government has the Quebec government has a number of issues, perhaps more prominent or important issues, political issues. The Charter of the French Language is currently before the courts. There has been the use of the notwithstanding clause. Our Charter of Rights and Freedom, the Quebec one, has also been amended to say that the Charter of Rights and Freedom of Quebec shall also apply, but so long as it does not suppress a right guaranteed by the Charter of the French Language. These are big hot potatoes. So we don't know if the government's going to say, as much as it makes sense to give an out for businesses, the government say, you know what, we don't want to open the Pandora's box. It's going to be too much and too many hands are going to go up. So best tip really is get yourself ready, work with people who have taken the time to study this and will give you practical advice and will not be too alarming.
Thank you, Keyvan. And I know we are at time. So there were a handful of questions we didn't get to. We will attempt to do that in the summary that we'll send out. For those of you in Ontario, this is eligible for an hour of substantive CPD. We'll also mention that in the follow-up email. And stay in touch with us. This series will continue as the legislation becomes more clear and as we head towards June. I wanted to thank our speakers for the time today and the excellent insights. It's invaluable. And the fact that you have been working on this project with your respective organizations as well as with the government consultations is very helpful and evident. So thank you to both of you for making the time to join us here today.
Thank you, everyone. Thanks so much.
Thank you to all our audience.
Thanks. Bye.